Good afternoon. Thank you for joining us today for a webinar that will answer some of those questions you might have on GDPR. Are we getting it right? I'll shortly hand over to Kevin McLoughlin, Chief Technology Officer at Integrate Agency CIC. Kevin's going to be delivering this webinar today. So we've got about an hour and a half allocated, plenty of time for questions at the end. So if you do have any questions that you think of now or during the presentation, do start typing those into the Q&A panel below that you should see, and I'll read those out for Kevin to answer following his presentation. Right, over to you, Kevin.
Thank you very much, Laura. Good afternoon, everybody. I hope everybody's well, and thank you for attending this webinar on GDPR. Am I getting it right? I hope you find it interesting and answers a lot of the questions that you may have, but as Laura says, if it doesn't, we'll stay online after, and my details on the screen there should you want to get in touch with me at a later date as well. Just a little bit about the Integrate Agency and what we do. Sort of two main sides to the Integrate Agency. There's the social enterprise side, and there's the cybersecurity, information security side as well. And primarily on the social enterprise side, the responsibility is managing agents and support services to provide access to funding, particularly government contracts by way of capacity building, consultancy, management structure, business strategy, business development, bidding services, partnership brokering, contract management, and the topic that we are discussing today falls under information and cybersecurity consulting. What we're doing with the Integrate Agency, we're trying to provide expertise on demand, connecting organisations with services such as data protection services, GDPR compliance issues, data protection officers as a service, so we can take all of that responsibility and that burden from you, and anything to do with GDPR compliance, dealing with the Information Commissioner's Officer, dealing with subject access requests, making sure that your business has the right documentation in. And we're currently providing that service for other organisations as well. And also on the more technical space, cybersecurity, incident management, training, education awareness, security testing. You might be aware of the terms penetration testing or vulnerability assessments of your IT systems, and then meeting compliance or certification to certain standards such as ISO 27001 and Cyber Essentials. Integrate Agency is doing quite well in the tech for good space. We're in the top 100 NatWest Social Enterprise Index and UBS One to Watch. And to back up the previous slide, we are currently delivering. I've got a couple of the companies that we're working with on the screen there, delivering GDPR and cybersecurity services to financial companies. We act as a data protection officer. For them, we take away the burden of GDPR and all of their compliance, but they actually get a little bit more because I'm actually dealing with a lot of their IT and their IT strategy and their IT security issues as well. And the premise behind all of that is they don't have to put an expensive employee downstairs for £60,000 a year, pay for their pension and pay for their computer, pay for their holidays. They just pay for what they need when they need it, and we supply that. We're delivering penetration testing to companies in London, and we've assisted housing associations and other organisations in delivering services to meet their GDPR compliance as well. And we're certainly on offer to do that for yourselves, which I'll come on to at the end. A little bit about myself. I'm the Chief Technology Officer and the Data Protection Officer at the Integrate Agency. Previous roles, I was the IT Director for the largest group of colleges within and training businesses within the UK. So I do have knowledge of IT. My background is primarily IT security and data protection, but I have knowledge of IT that I can bring it into the spectrum as well. And some of you might actually be aware of the company NCG. Formerly they had with them the Integrate, in training and Rathbones. And I was IT director for both of them companies as well. I was also the group head of information system security, and at Northumbria University I was the head of IT and information security there. Previously worked at Northumbria Police in IT and a tutor in data protection. So I do have a wealth of experience, which is at your beck and call now. And I do come from a background working within education, employability and work-based learning. I've worked quite heavily with the DWP security teams. They're probably the most strictest organisation I've ever worked for in relation to security. And if you have any concerns, I can certainly ease that burden and assist with anything that you've got with organisations such as the DWP. I actually really enjoyed working with them, to be honest, because you know where the lines are drawn, you know exactly what they want. And even though they were quite stringent, working together with them, a lot of the work I did, not in a conceited way, I helped them relax a lot of the stringent security controls they had in place. So I do have a background in working with organisations such as that on contracts like the work programme you might be familiar with in Welsh Assembly Government, and advising organisations on information security issues and compliance to data protection laws and the standards such as ISO 27001 and Cyber Essentials. So what's in the news? There's plenty going on at the moment, and I don't know whether it's a case of people think that GDPR is in the rearview mirror now. A lot of hot air about it last year, but does it really affect me? Technology's growing at a rapid rate. We've got mobile devices, we've got on-premise IT, we've got hosted IT in the cloud. People are using mobile phones and tablets and laptops when they're out and about. They want accessibility, they want portability. We've got the Internet of Things. And there's certain websites out there now that provide the hackers and the malicious attackers a lot easier route to access into your business and the data that you hold, and maybe to corrupt or deny access to that data. So I certainly don't think that GDPR is in the rearview mirror. And I'll try and demonstrate that in a moment. But you ride the big wave of risk if you're going to approach legislation in that way. So it's on the slide there. It's not a case of if you'll be attacked, but more like when. If you haven't already, and you might just not be aware of it. Looking at some of the ICO enforcement action, the ICO, the Information Commissioner's Office, regulate data protection within the UK. Investigations, and they do the audits. And I've put a couple on the screen here that I just wanted to highlight. The first one, Life at Parliament View fined £80,000 for leaving 18,610 customers' personal data exposed for almost 2 years. And I've put in bold certain key points here. Why does that one stand out? Because the data was exposed for almost 2 years. And I've investigated a lot of people in my time, but people who've acted maliciously, it's got to be 0.1%, maybe even less than that. The majority of people I investigated who'd had security breaches were just a lot of good people doing difficult work under difficult circumstances. They took their eye off the ball for a split second, and then all hell's broken loose. And a lot of these things were actually preventable. But what they do is these breaches or these vulnerabilities that are waiting to turn into a breach, they're missed day to day by employees because they've just become part of the furniture. People don't go back to their organisations with a new set of eyes, a fresh set of eyes, and say, you know, let's start having a look where there's a possibility of loss, theft, or compromise of data. And these things will be there for a long time, up until the point where the exposure happens, and then you start to use that word hindsight, which is one of the reasons we do these presentations, is to try and get you into a position where you never have to use that word hindsight. Why didn't we just, what we should have done is, the amount of people I meet that don't know how to put a password on an Excel spreadsheet, who don't know how to put a password on a Word document. If you're using Windows 10 Professional, anything other than the home version, which you should be because Windows 7 is about to go out of support, you've got the ability to encrypt laptops and encrypt mobile devices through BitLocker. And people don't know how to do this, and they lose data when in fact it was preventable. They could have put a security control in place which would have prevented disclosure such as a password or such as encryption. Next one, Hudson Bay Finance Limited.
Kevin, sorry to interrupt you. We can't see your slides. Are you able to reshare?
All right, okay, yeah, definitely. 1 second. I did see your screen pop up for a split second, so how's that?
Fabulous.
All right, thank you, everybody. Technology, don't work with children or animals and technology now. Okay, so the next one, Hudson Bay Finance. You can actually look at these on the ICO website. They're not confidential. They publicly disclose them on their website. But the Hudson Bay Finance issued with an enforcement notice for failing to respond to a subject access request. Not only did they fail to respond to the subject access request, i.e. they ignored the emails that the data subject was sending in, they actually repeatedly ignored the ICO. And you can read about it on the ICO web pages. The ICO said regulate data protection in the UK. They allocate and issue out the fines and the penalties. Why do you want to ignore the people that do the audits, investigations? But it was just a series of events that were ignored that led to action being taken against them. One thing you can't do within the data protection laws is you can't deny an individual their rights. It's going to put you into a high fine bracket, and the law's been changed, and it now strengthens the rights of the individual. And denying an individual their rights, unless you've got, you know, a clear, precise justification to do that, and ignoring the ICO as well, is only going to put you into an area where they're potentially going to take enforcement action against you. The next three on there, the customer service advisor, the justice caseworker, and the head teacher. The reason I put them on is a lot of people, it's a bit cliche, it's a bit like the health and safety that we have in organisations, that the cliche term is it's everybody's responsibility. Well, data protection is everybody's responsibility, because as an individual, you can be fined. You can't hide under the umbrella of the organisation. As an individual, you can be fined as well. And if people are aware of that, then maybe they can be a little bit more attentive to what their responsibilities are in protecting people's data. And it's not just about protecting your client's data or your customer's data, it's your data as well. And you wouldn't want organisations denying you your right, and you wouldn't want organisations mismanaging your data. So them three on there are just to highlight that individuals can be fined as well as organisations can be fined. And the fines have gone up quite substantially now. 20 million euros or 4% of global turnover. Hence British Airways were hit with a potential fine of 173 million. And some of these fines can potentially end a business if it's that substantial. And I want to put on at the bottom there, Alistair Green Legal Service, a legal company. You'd think they would know a little bit about data protection, but who knows? The reason I put that on is because it's a small amount of calls, but it's quite a huge fine in my opinion. A lot of the enforcement action you see on the ICO web pages will be a £100,000 fine for 200,000 emails being sent out, sort of incidents sort of in that nature. But this one is £80,000 for making 230 nuisance calls to people that were telephone preference and service subscribers. So it's not a great deal of calls, but that, in my opinion, that is a huge fine, and that would rock the foundations of some businesses. And if you do have marketing within your organizations, I would actually get some advice on how to approach marketing, who you can, who you can't, because you're not actually just governed by GDPR on marketing, you're actually also governed by the Privacy Electronic Communication Regulation. And you've got certain constraints placed upon you to who you actually market and how you market. If it's technical, if it's by text message, if it's by email, the Privacy Electronic Communication Regulation comes in. And you may need consent to be able to market, and you need to look at whether they're an individual subscriber or they're a corporate subscriber. Are they a private person with a private email, or is it a corporate email? Don't just go off down the road of marketing without making sure that you are doing it in the right way. And consent plays a heavy part in that, and consent is the only legal basis under Article 6 that has its own article, which consent comes under Article 7. But in brackets I've put DPA 1998. Some of the enforcement action you see on the ICO website, they're still catching up. And even though the GDPR has been in for over a year now, they're still actually fining people under the old legislation because of the amount of breaches that they had to catch up on. So GDPR came enforceable in 2018 on May the 25th. It didn't come in on May the 25th, it became enforceable. It actually came in 2016. The text was adopted in 2016. And even though there has been amendments, organisations were given a 2-year sunrise period to get ready for GDPR when the enforcement date of the 25th of May came in. A lot of organisations still haven't done anything. And even what I saw, a lot of organisations didn't actually become aware of this until January 2018. I don't particularly think the ICO's awareness programme on this was as good as it could be, but it is now enforceable. And it sets out very clear ways in which privacy rights of European Union citizens must be protected and can be used. Is it affected by Brexit? Yes, it is, but we'll cross that bridge when we come to it, when we're certain on what Brexit's going to look like. But certainly the transfer of data outside of the UK will be something that will be affected by Brexit if Britain decides to leave the European Union. It places the onus on any person or entity involved in the processing of a person's information. And I've got in brackets there, data controller, data processor. Whenever I go and help an organisation, whether I advise, assist, or whether I'm doing an investigation, first question I always ask is, who's the data controller? And there's certain terminology that helps you understand that. The data controller is responsible for determining the manner in which that data is going to be processed. A data processor isn't somebody that sits in an admin office and processes my mileage claim to give me my petrol money back. Even though they are processing, that's not what a data processor is in the eyes of GDPR. And you want to understand these two terms so you understand where your business is. A data processor processes data on behalf of the data controller, and it's under instruction and it's under authority that they're an extension and they're carrying out your wishes as a data controller on how you want them to process that data. And it is mandated under Article 24 and 28 that certain things need to be in place. If you are using data processors, you're mandated to have a contract in place. You're mandated to make sure that you get assurances from them that they can process data safely and securely as well. But with the changes in GDPR, data processors can't now hide under the umbrella of the data controller. Data processors can be equally liable and can be given penalties and fines. So they are processing data. They should have their act together in their own compliance with GDPR, even though they're processing data on behalf of the data controller. So it's important to know them terms. You don't have data owners. The people who own the data are the subjects themselves. You have data controllers, data processors, data subjects. I've said before, carry significant penalties for non-compliance. And I already mentioned there, GDPR states the data controller determines the purpose and the means of the processing, whereas the processors act on behalf of. Information security is not that difficult. It normally comes under what's called the CIA triad: confidentiality, integrity, and availability. And I've just put this on to say that information security and protecting data is not that difficult. You prevent unauthorized access and you prevent loss, theft, or compromise of that data. Confidentiality, only people authorized to see it should be able to see it. Integrity, can we keep it as it is? Can it be unlawfully or unauthorized, manipulated, modified, deleted, corrupted, etc.? And then availability. Confidentiality and integrity. If you lock something away in a cupboard and never let anybody get to it, then you don't have to worry about confidentiality, integrity, because nobody can get to it. But unfortunately, we don't live like that. That's where the availability or accessibility comes in. As soon as you make data available, whether it's via the cloud, whether it's in paper form, whether somebody takes it away from the office in paper form, whether it's on a USB, whether it's on a laptop, whatever the case may be, that's where risk comes in. And what people don't do is they don't identify what the risk is and they don't manage that risk. And then that leads to unnecessary breach and then unnecessary people going through disciplinary and potentially unnecessary dismissal. So think about the CIA: confidentiality, integrity, availability. You prevent unauthorized access and you prevent loss, theft, or compromise. And that can be as easy as hard as you want to make it. It could be locking a filing cabinet, locking a door, right through to technical security of firewalls and web filters and mail filters. But when it comes down to securing that data, I spoke to somebody the other day who said, Kevin, we need a bit of assistance because the person that was writing our policy is gone and we need the policy to make us compliant with GDPR. I just didn't understand really what they were getting at. What do you mean? A policy doesn't make you compliant. Article 5 in brackets 2, you've got to be able to demonstrate compliance, and how you do that is not via a policy, it's via a multitude of things. But when you come to protect that data, it's written in bold there, you've got to consider risk and the varying likelihood and severity. And towards the bottom, GDPR doesn't tell you to lock the door, it doesn't tell you to put data in the boot of a car, it doesn't tell you to password protect, it doesn't tell you to encrypt. It recommends encryption and pseudonymization. What it says under Principle 6 is that the controller shall implement appropriate technical and organizational measures. You've got to determine what that appropriateness is. And that's based on what the data is, and if it gets lost, what is the impact on the individual and their rights. So if there's a bit of paper with somebody's name on, and it's letterheaded, so it is aggregated, you can identify a living natural person from it, and it's lost in the street, well, how much impact is that going to have on the individual? It's just a name. Well, their name's probably on Facebook, their name's probably on Twitter, LinkedIn, etc. But it will still bring them a level of distress that you've got to manage. That's totally different to telling somebody you've lost a USB in the town, and on that USB is their whole life. It's got their medical records, it's got disciplinary, it's got financial details on, it's got a whole bunch of stuff. Security costs money at the end of the day. I wouldn't expect to see a strong room and a safe put in for just a piece of paper with somebody's name on, but I also wouldn't expect to see a USB without any encryption or password protection on the files that's on it, left, you know, in a public waiting area, public area of the business, or taken off premises without some sort of risk assessment done of it as well. So you've got to look at what the impacts is. What we're saying is you've got to look at risk. It's mandated under Article 25. Article 25 is about privacy by design and by default. You've got to make sure that privacy of individuals is embedded through your processes and your procedures by default. Article 32, security of processing. I've just pulled out some key terms here. Risk comes up again. So if you have no risk management in place, and don't overcomplicate it, we can help you with this. It's an easy thing to advise somebody on and get them up and running with a risk register that they'll totally understand. You don't have to get too deep into risk as well. If you've got 10 laptops and each of them laptops cost £1,000, then what's the value? The value is £10,000. But what if each of them laptops have got a spreadsheet on with 5,000 people's sensitive personal data on? Well, the value isn't £10,000 now. It's whatever the potential loss is in relation to GDPR. And that's quantitative and qualitative risk. So you don't need to get too deep into it, but you do need to manage risk because you're mandated by the articles within GDPR. And it says there about confidentiality, integrity, availability that I just mentioned. And then the third bullet point, you need a process for regularly testing, assessing and evaluating the effectiveness of your controls. Don't just let them merge into the furniture. Go and have a look, have a review, go back and have a good look at your end-to-end process and ask yourself a question. How risky is the data? Is it somebody's name, or is it more sensitive information about them? And then look at the end-to-end process and look to see whether there's a possibility of loss, theft or compromise there. And then it says at the bottom there as well, account shall be taken in particular of the risks of accidental or unlawful destruction, loss or alteration. So just some essences of what's actually written into the text now. Evidence is everything. I've had to endure several ICO investigations. Probably not a good sales pitch for me, mine, but they're not the most comfortable thing to do. They're not the most comfortable thing to endure, but evidence is everything. You've got to be able to put evidence of the action that you've taken to minimize impact to the individual and what security controls were in place at the time. At the time of GDPR, the Information Commissioner came out with 12 steps to compliance. I've had companies phone me up and say, Kevin, we'll come and help you with your GDPR compliance. We've got these 5 steps, so we've got these 7 steps. Well, yeah, sure, I had 12, so you're missing 7 or you're missing 5 steps. But actually, I've highlighted number 2. Number 1, becoming aware. Becoming aware isn't really becoming aware of data protection. A lot of people, they know what data protection is. They have an understanding that they've got to manage and protect people's data at work. Number 1 is really about what your obligation is under GDPR as a data controller or as a data processor. And number 2 is very important. It's my start point for everything. It is mandated potentially under Article 30. You've got to maintain registers of processing. This is nothing to do with a policy, and this is nothing to do with a privacy statement. You document all of your processes and you align them with the relevant articles to GDPR. So you might have a recruitment process where you recruit new staff and you advertise online, and they go in and they fill out a form online. Well, that's the point of data capture. Anywhere that you capture somebody's data, you need to have a legal basis under Article 6. You need to inform them and be transparent under Article 13. If you're passing that data on to somebody else or a data processor, you need a contract under Article 28. Can you affect the rights of the individual? Articles 15 through to 22. Can you delete? Can you rectify? Can you give them access? And you also document how you're securing that data as well. And you do that for all of your processes. That's called data mapping, or documenting the information you hold, or maintaining records of processing. But if you get that right, you get everything right. But it's got to have depth to it. It can't just be a linear spreadsheet. And I've helped a lot of organizations do this. And once they're up and running and they're on their way, then it's just a case of maintaining it and maintaining that compliance. Because if you get it right, then you get number 3 right. You'll know whether your privacy statements are in place. You'll know whether you can affect the rights of the individual, 4 and 5. You'll know whether you have the correct legal basis in place, and whether you comply with consent if you're using consent as your legal basis. Are you processing children's data? And do you, number 10, do you assess risk? Do you do, under Article 35, data protection impact assessments? So if you get number 2 right, you get all of them right. And the only ones that will stand out is, do you need a data protection officer? Not everybody's mandated to have one. Do you transfer data overseas? Number 12, and do you have a policy in place and practices in place for reporting breaches? So if that's what the ICO recommended, why would you not want to comply with the organisation that issues out the penalties and the fines? But what does compliance look like? Well, under Article 6, there's 7 principles. Some people refer to 6 principles, but I've put in brackets there 7. These are the principles that come under Article 6. Anywhere that you process data, if you can align that processing to at least these 6 principles, then you're probably getting Principle 7 right as well. Principle 1, lawful. You've got to have a lawful basis under Article 6. You can't have, you can't just make it up. You know, you've got to have the correct lawful basis for processing. And apologies there, the principles come under Article 5. Your lawful basis comes under Article 6. Your lawful basis are contract, consent, another legal obligation, public interest, vital interest, or legitimate interest. And legitimate interest, sadly, isn't the catch-all it used to be. You've got to balance the rights of the individual to your processing and do a legitimate interest impact assessment. So you've got to have a lawful basis. It's number 1. It's got to be fair. It's got to be what the individual would expect, and you've got to be transparent. And transparent's the new part. This is where your privacy statements come in. And you'll have seen last year a lot of privacy statements coming into your email boxes. Organisations updating their privacy statements to fall in line with Article 13 and potentially 14 as well. Privacy statements have got to be written in a way that the average reader of that privacy statement can understand. There's no age restriction on data protection laws other than the age of 13 for people registering for online social services. So if you've got a privacy statement that's aimed at 14-year-olds, then it's got to be written in a way that 14-year-olds will understand. It comes under Article 12. And so if you're using terms like data controllers, data processors, and stuff like that, then they're probably not going to understand it. Purpose limitation, you should only be processing the data for what it was originally captured for, and not further processing it in a manner that's incompatible with what that original purpose was. So you can't go and use that data for anything other than what you've informed the individual about, without informing them again and being lawful and fair and transparent. Data minimization, you should only be collecting what you actually need for them purposes. Unless it's actually better. When I've dealt with some really complicated subject access requests, the less you've got, the less you need to provide on a subject access request or deletion. So you should only be collecting what you actually need for that specified purpose of processing. So if your web forms are asking for people for what maiden names are, mother's maiden names, and the pet's names, and one thing and another, and you don't need it, then you'll have to review that, because one, it's better to not have it, but two, it comes under data minimization. Principle number 4, accuracy. If you've ever had the telephone call, you were involved in a road traffic accident in the last 2 years, and I had one this weekend, turn around and say to them, excuse me, who are you? Oh, we're claims director, or whatever they're called. What do they call your name? My name's John. John, I'm going to be putting in a request for action with the Information Commissioner because you're in breach of the data protection laws. How? Well, principle 1, I don't know who you are. You haven't given me a privacy statement, so you haven't been transparent. And principle 4, accuracy. Data must be accurate and where necessary kept up to date. Your data is not up to date because I can't have been in a road traffic accident, I can't even drive. So you've got to make sure that it's kept accurate, it's kept complete, kept up to date. You shouldn't be keeping it for any longer than absolutely necessary. So I see people now that have got data going back to 1991, and they don't have a legal basis, and they don't even know why they've got it. So you can't keep it for any longer than actually is necessary. And number 6 is your security. Appropriate technical and organisational measures need to be in place. The 7th principle, which is Article 5 in brackets paragraph 2, accountability. The controller shall be able to demonstrate compliance. If you can't demonstrate compliance, it puts you into a high fine bracket. It's got at the bottom there, proof of care. The reason I put that in is wherever you process anybody's personal data, especially if it's high risk data, you want to be in a position where you can prove care has been taken. And I said before, that's evidence. Evidence is everything. So wherever you are processing data, if you can align it to at least them 6 principles without getting too wound up with all of the different articles, then that's not a bad start point. Mentioned the legal basis before. Comes under principle 1, it's got to be lawful, fair and transparent. And mentioned the different criteria that you've got: consent, contract, another legal obligation, vital interest, public interest, or legitimate interest. And even though the 6 there, it can go a little bit wider. Another legal obligation, you could be processing somebody's data for health and safety. It'll be a regulation or legislation. You could be capturing somebody's data as they come into your business because of fire regulations. You need to know who's on the premises. You might be processing people's data for safeguarding, or the Employment Act, or employment legislation, or the Education Act. I'm not a lawyer. I don't know all the laws of the land. What I do know is principle 1 of GDPR expects you to process data in a lawful fashion, and that's the 6 that you've got to choose from. So what you can't do is, if I came into your business and said, well, I've got this data here, why are you storing it? You can't turn around and say, just in case. It's got to fall under one of them lawful basis. And it, as it says there, it should be recorded. So you've got to look at the data that you've got, and you've got to look at the data that you're capturing as well, and go back and review it and align it to the articles and start to document it. Wherever you process somebody's data, you've got to have security in place. You've got to have the privacy rights of the individual first and foremost, and your processors have got to have security, a bit of a gold thread through the fabric of that process and by default. Data protection impact assessments come under Article 35, but they don't need to be done for all processing. Under the old data protection laws, DPA 1998, the term was sensitive personal data. Now, they don't use that term now. It comes under Article 9, which is a special category of personal data, which is sexuality, which is political affiliation, ethnicity, etc. Generally, what people can be discriminated against. And if they do, if any of the data that you're processing falls under Article 9 special category, then it's high risk, and you want to think about doing a privacy impact assessment on there, because that not only allows you to do a gap analysis and look for any areas of loss, theft or compromise of high risk data, but it also gives you evidence as well that you're trying to comply with the data protection laws. When you're capturing that data, you want to think about your lawful basis, and only capturing what you actually need. And are you being transparent? Are you notifying individuals? Have you got a privacy statement that complies with Article 13 or 14, depending on how you've got that data? And if it's consent-based, don't always opt for consent. Sometimes consent isn't the best legal basis to use, but consent is the only legal basis that has its own article. It comes under Article 7. That it's got to be unambiguous now. It's got to be easy to understand. You can't hide consent away in terms and conditions. You can't have pre-tick boxes on websites. You've got to be able to capture it. You've got to be able to evidence it. And you've got to be able to provide to the individual their ability to withdraw consent just as easy as it was to give consent. And there's a bit of mutuality there between you and the individual. That's why you would never see consent as the legal basis for employment, because it's not a level playing field. It's got to be contract, because you can't have employees withdrawing their consent to be employed. So if you are using consent, one, determine whether it is the best legal basis to use, and two, make sure that you're fully compliant with what's expected under Article 7. When you're storing this data, go and have a look at it. Go back and take a look, and go end-to-end processing and look at all the different hops and determine whether it's safe and secure. Is there a possibility of leakage? Is there a possibility of loss? Is there a possibility that people taking data away from the office, not only taking data away from its office in paper form or digital form, but I've seen people take the whole file contents when actually all they needed was 2 pages. So looking at that, taking data away from its normally secure location and where accessibility and risk comes in, review them processes and back that up with education, training and awareness, and make the employees aware of what their obligations are when they're dealing with people's data. If you've got IT systems or even paper-based files, restrict access where you can, and bring in access control. Lock files away in filing cabinets and doors, and put the alarms on, and lock the windows. It's what we call defense in depth. Don't have one layer of defense protecting that data, have several layers, but make it proportionate to the data that you've got, because as we said before, security costs money at the end of the day. Map out your processes and the data, and that will allow you to do the gap analysis to make sure that you are hitting all the areas of compliance that you need to. Can you deal with subject access requests? Can you deal with deletions? One of the parts of GDPR that brought a lot of noise with it was that people have the right to be forgotten, the right to deletion, Article 17. It's not actually absolute, and there's a few urban myths that are starting to come in now that I hear people saying, oh yeah, organisations have got to delete your data. Well, it's not absolute. If you've got a legal basis that trumps their right to deletion, then their data doesn't get deleted. I'll give you an example. I say to an organisation, I want my data deleted, and they turn around and say, Kevin, unfortunately, tax laws say we've got to keep this data for 7 years. Okay, they've got a legal basis to keep it. But what do they need to keep? They don't need to keep my whole life. They need to keep what's proportionate to that legal basis. The other thing with deletion is, to delete somebody's data, you need to know one thing. You need to know where it is. And you've got a timeline to adhere to on subject access requests, mostly 30 days. People's data is in emails, it's in the body of emails, it's in attachments in emails, it's in databases, it's on USBs, it's on desktops, it's in cloud storage, it's in Dropbox, it's in OneDrive. People's data is everywhere. We've lost control of it. And what the ICO won't allow is for your bad management of data to be an excuse for not giving them or carrying out their wishes of deletion or access to data. So you want to go back and have a look at what your information assets are, and can you affect the rights of the individual? Do you have contracts in place with data processors, and can you deal with data breaches? Do you have a data breach policy in place? Do you rehearse data breaches? Do you tabletop exercise data breaches? Do you talk through the breaches with anybody on who they would call? Who would you get in touch with? And how would you manage that potential breach? When you come to use that data, make sure it's used appropriate and fair, and it's in a manner conducive to what the data subject would expect. And that's underpinned by having some sort of education, training and awareness regime, and a culture that goes alongside the use and management of that data as well. And then when it comes to destroying it, do you have retention periods? Do you have a retention policy? You're actually mandated under Article 13 to tell individuals how long you'll keep their data for anyway. So you should have retention policies and retention periods in place. Can it be erased? And if you are using data processors, it's not just erasing the data that you have, it's making sure that wherever that data is, that the data processors at the end of the contract can return that data or destroy that data, and that should be written into your contract as well. I've seen instances where organisations have went to a data processor and said, look, we've got a subject access request come through, we need copies of all of this data. And the third party have said, look, we don't have time at the minute. If we do, I need to take 2 people off a project they're on to go and find that data. And our daily fee is £1,000 a day. And that comes as a bit of a shock. That wasn't discussed at the beginning of this relationship and put into the contract at the start. Doesn't matter, you can't deny the rights of an individual when they make a subject access request, a request for deletion, a request for rectification, or a request for portability. So you need to understand as well what the rights of the data subjects are, and then align them with your systems to see whether you can actually facilitate them as well. Don't wait for one to come through. Some of the things that I've seen, I spoke to a lady, I said, who manages your data protection? And she says, in what way? I says, well, you're in breach of the data protection laws. And she went, how? I says, because you're a data controller. And she said, how am I a data controller? I says, because your business payrolls 25 people, which means you determine the manner in which their data is being processed. That makes you a data controller. And you're in breach of the Data Protection Charges and Information Act 2018, which says that you've got to register with the ICO and pay them a fee. If you don't, you're liable to a fine. The reason I'm saying that is I still meet organisations that don't understand that they are a data controller and they're not registered with the ICO. It is tiered. The lowest is £40 and the highest fee is £2,900, depending which tier you fall into. But the ICO have said in 3 separate newsletters this year that they are now starting to hunt down organisations who are data controllers that are not registered with the ICO. Still see organisations doing what they think to be right because it's an assumption, but they're not compliant to the law, especially when they come to profile individuals and then they start to market them and sharing data because they're working on assumptions and they're not working on the facts of what's written in black and white. You ride the wave of risk if you're doing that. Personally, I would say get some advice and do it the right way, and then don't get into a position where you potentially need to use the word hindsight. Organisations, whether you're mandated under Article 30 or not, it's still the best practice you can put in place to determine all the processes that you have where you process somebody's data, whether it's high risk or not, how you make them aware, legal basis, secure, exercise the rights of the individual. And that's my start point for any organisation I help. And generally, once I've got them up and running, they'll say, Kevin, I've got it, leave it with me. Don't need to say anymore, totally understand it. It's not that difficult, and then it should just become part of your business as usual processes. Mentioned before about marketing. If you are marketing, make sure that you have your processes right. Don't work on assumption, work on fact. If you're not sure get some advice, and we're more than happy to guide you on that. Look at your IT and associated tech, not just to do with the protection of data, but single points of failure, backups, single servers. I've seen one of the things that scares me most than anything in the world is viruses that come around and encrypt all of your data. But there's other single points of failure. Somebody takes a cut of somebody's data off a system, puts it onto a USB. They take the USB out, it gets lost, and that was the only copy of the data that they had. And that's become a single point of failure that people haven't identified and done some sort of risk assessment or analysis on it as well. And you can do that with your IT and the way in which you manage data. Data is only ever in three forms. It's either transported, transmitted, or it's at rest. If it's transported, it could be on a USB, it could be on a hard drive, could be on a laptop, could be paper. You take it from the office, you put it in your bag, you put it in the car, and you drive it somewhere, home, to work, on whatever. That's transported. Transmitted, you're sending it via email, you're sending it through a file transfer system, or you're sending it via a form on the internet. So that's transmitting data. And then you've got at rest. It's at rest in a data center, it's at rest on a server, it's at rest wherever it's situated. And you've got to apply security to them three mechanisms, but apply that security in depth. People are still clicking on links. People are still opening attachments. Education and awareness and getting that culture within the organization. People have still got data going back years. They're holding on to it because of just in case. They've got unmanaged data. Nobody's taking control of it. Boxes of archived data sitting in storerooms out the back of the building or in file shares that through a restructure in the business, nobody deals with it now. Nobody takes ownership. It's just sitting there, and you don't want and you shouldn't have unmanaged data, whether it's paper or digital. A lack of general compliance to GDPR contracts and assurances from data processors. Know what your obligations are as a data controller under Article 24. If you are using data processors, you should have contracts and assurances in place that they can process data safely and securely, and they are operating under your authority and your instruction. I'm still meeting people now that are transferring personal data overseas, and they're totally oblivious to what GDPR expects of them. And they don't apply the right security controls based on their risk assessment. And then the bottom one, because they don't think it's important. And you can determine that based on the data that you're processing and the complexity and how high risk that data is to the importance that you put on meeting this new legislation. Some tips for compliance. Do you have a GDPR lead? Do you have a champion? Do you have a DPO? Maybe something to think about. There are people in organisations that do have an appetite for IT, do have an appetite for this type of thing, and they're willing to take on a little bit of extra responsibility. Said it time and time through this presentation, maintain records of process, and if you get that right, you get everything right. Make sure you've got support from your senior management, your senior leadership teams, get your board and your executives to buy into it. As we said before in the ISO action, individuals can be fined as well. Are your privacy statements correct? Do you have agreements in place? And I see people getting this bit wrong. You have a contract in place with the data processor. You have a privacy statement in place between the controller and the data subject, and you have an agreement in place between two data controllers that are sharing. You're mandated to have a contract in place, and you're mandated to have a privacy statement. Data sharing agreements between controllers is not mandated, but it is recommended. And I see people getting them documents a little bit confused, and I've seen amalgamations of all three of them in some cases, and reading it, you can see what they're trying to do, but they've just got a little bit confused along the way. Have you got appropriate security in place? Can you exercise the rights of the individual? Go back and have a look and talk through it and see. And tabletop exercise may not need to be as heavy as that, but you know, if a subject access request came in or a deletion request came in, especially the way some of the older databases work, trying to delete data could have potentially affect the rights of another 1,000 people in that database, because as I said before, the way the linkages work. So it's something to have a look at. Breach report and incident management. As a data controller, if you have had a breach, you you're mandated to inform the individual, you're mandated to inform the ICO if the individual is perceived to be at high risk. But if you can demonstrate that controls are in place, encryption, password protection, and there's been no disclosure or compromise of data, then you're not mandated, potentially not mandated to inform the ICO. But you do want to make sure that you rehearse or have clear guidance on breach reporting and incident management, because if it is ICO reportable, you've now got 72 hours to notify the ICO, and if you're a data processor, you've got to notify the data controller without undue delay. Mentioned before about marketing, get that right. That's where a lot of the fines are happening if you go into the ICO enforcement action. Make sure you get some advice on doing that correctly. For marketing companies, they had quite a wide area to operate in before. They can still operate, or people can still operate, just there's a narrower channel now for how they've got to operate because of the nuisance calls and the nuisance emails and everything that's gotten on people's nerves over the last few years. If you're sharing data, or you shouldn't be receiving data, buying data, selling data without compliance to GDPR and letting individuals know that you've now got their data. What you shouldn't be doing is letting people know that you've got their data but marketing them in the same email, because organisations have been fined for doing that as well. And at the very least, understand the 6 principles and the 6 lawful bases. If you can align your process into the 6 principles, not a bad place to be. But you might have holes and gaps elsewhere, definitely in your security, that could lead to breach. And Article 5 in brackets 2, can you demonstrate compliance? Are you being accountable? Because if you can't, evidence is everything. That puts you into a high fine bracket. Maintaining records, that's just an example. And the spreadsheet, if you can see the slide, would go right over to the right-hand side. I can only get so much onto the screen. But why do we process that data? Who? What are we actually capturing? We get a name, we get address, etc. National insurance number. What's the legal basis? When do we capture it? How do we capture it? What's the legal basis, and what's the retention period, and what determines that? Where do we capture it from? And then it would go all the way to the right-hand side. Are we a data controller? Are we a data processor? Do we have a contract in place? Do we have assurances in place? How do we protect that data? Do we have privacy statements in place? Can we exercise the rights of the individual? And if you do that with all of your processes and you red, amber, green it, anywhere that's green, that's fine. I certainly have never seen a register that's all green, because I don't think there is such a thing as total compliance, because your systems are changing all the time. Processes are changing, implementing new technology. GDPR is maturing as well. If there's ambers and reds, that's a good thing, because that means there's action that needs to be taken on your part to improve and meet your compliance as well. And if you do understand what needs to be done, seeing a red and an amber is quite healthy. It's better to see a red and you know what work needs to be done than seeing a red and you don't have a clue what it is or what needs to be done. So if you get the registers right, you potentially get everything right, and it gives you that gap analysis and the action plans on how to be able to demonstrate and then keep maintaining that compliance. If we can help in any way, we are on the ERSA website, and we offer cybersecurity and data protection services. If you go into the membership, and then on the left-hand side, cybersecurity and data protection services, and you can get in touch with us via that. Or if you want to go back through this slide deck, my details, email address and telephone numbers on there as well, and would be more than happy to come and help. We want to provide as a services if we can, so you get the best service possible, but you're paying the least amount possible for that service as well. Let's help with the bits that you need help with, and attack them issues that may lead to breach, and send you on your way until you potentially need that next bit of support. Or we can act as a total data protection officer and take all that burden from you, deal with the ICO, manage all of your data protection services, and if need be, ease all the burden of the contracts that you've got with the DWP and Welsh Government, because I have worked with them organisations before. So I hope you've enjoyed it. I will be staying online to answer any questions you may have, but thank you for attending today. And over to Laura.
Thank you, Kevin. That was really interesting, informative, and a little bit scary.
2 minutes to spare as well.
We've got some questions here already, but just to remind attendees that we do have some time if they want to still add some in. Let's have a look. So we've got, are there any template privacy statements and checklists available?
Yeah, definitely. There's 2 ways to look at this. Google has an abundance of these things. We all know that. But we can help with that as well. We've got templates and contract templates, data mapping, risk registers that we can help with. What I've said to a company that I've just recently engaged with is, I could send you the data mapping register. But what I would also, and this certainly isn't touting for business, this is trying to get you on your way, I would certainly say that needs to be followed up with a telephone call that describes and explains that register, and then you'll get it. You will. My wife got it, and I can't teach my wife anything to do with IT or GDPR, and she's a business manager in a school. And once she was on her way, she says, look, I totally get it. I see how important this is. So sometimes it's not just about having the template. It's having that little bit of knowledge to go with it to send you on your way. So if you want to get in touch with us after, we can see what we can provide them templates for you, or and we do have a bunch of stuff. So to answer that question, we can supply that and give the guidance on it. But now that GDPR is starting to mature as well, there's a whole bunch of stuff out there. What I would say though is, make sure that what you've got is actually the right thing. I'm dealing with companies at the moment that believe because they've got a policy in place, they're now compliant with GDPR. But wait a minute, you're sending data overseas to India. Your policy is not going to make you compliant with sending data outside of the European Union, because you're in breach of so many other articles. But they've fallen into this mindset that they've got this policy and this template, and somebody's helping with it. That's it. They're done. So there's plenty of stuff. We've got plenty of stuff. Get in touch with us after, and we can help with that. Is that okay? Does that answer that?
Great, thank you. Yeah, if you wanted to any more on that, whoever asked that, just put another comment in the box. So let's go on to the next one. We've got, I think you might have touched on this one actually. How long is too long to keep files from previous employees and applications and CVs for jobs, etc.?
Oh, what a good question. Whoever asked that question, that's a good question. Right, when you do deletion is absolute. It's the reason I'm starting here is it's like the term impossible. You'll hear people turn around and say, hey, that's virtually impossible. There's no such thing. Something's either impossible or it's not. And deletion is the same. If you delete something and you've done it properly, then it's gone. You can't partially delete something. So when it comes down to deleting data, make sure you know that what you're deleting, you have no need for any longer, and what you do have a need for, and you are going to return it, you've got a legal basis for it under Article 6. Now, when it comes down to your retention, mention CV there, and when you look at your data mapping as well, and you saw the example there, this is the data that we've got, and you've got a retention period, and it's determined by their columns on your data mapping register. So let's say as part of a recruitment process, somebody goes online and submits their CV. Well, there's got to be a legal basis for that, and because they're applying for a job, that legal basis is more than likely going to be consent, and they'll click the consent box on the web form and upload their CV. Now, in your privacy statement that you should put somewhere in there about data retention. Now, if your privacy statement says that your data, for unsuccessful applicants, your data will be retained for no longer than 6 months following the application process, then you've notified the individual, and you shouldn't have anybody's CV that you haven't employed any further than 6 months after when they first applied. So you've got a retention period that's governed by something, and in this case that I've used there, it's by your privacy, the privacy policy that's telling them that. Now, if somebody has been successful in a job, then you're probably going to retain their CV as part of their employment pack. But the legal basis now changes as well. It doesn't go to consent, it now goes to contract. And then within that contract of employment, you've got to give them a privacy statement because you're mandated under Principle 1 to be transparent, and you've got to tell them how long you're going to keep their data for. And that's determined by, that could be determined by what's written in your privacy statement. That could be determined by employment law. Now, as I said before during the presentation, and this is not a cop-out, I don't know, I don't work in HR, I don't know employment laws, I don't know health and safety laws. All I'm saying is, under potentially another legal obligation, under Article 6, your legal basis, there may be something else that will determine that you can retain that data for longer. But what you can't do is you can't keep it for just in case. You've got to align it with a legal basis. So my part in advising on GDPR is to say, whatever data you have got under your roof has got to align, every bit of that data has got to align with one of the 6 under Article 6. How long you keep that for is determined by that legal basis, or how long you've told people as part of that transparency that you're going to keep it for the period of their employment plus 1 year, etc. But it's about aligning the data that you've got to having a legal basis and making sure people are aware that you've got their data. Hope that answered that question. I can't be, I can actually, whoever's asked that question, and if there's anybody else that's got the same query, what I can do is I can work with you and I can look at that data that you've got, and I can, through a question and answer session, say, tell me about it, why have you got it? And then we'll make it fit the right legal basis. But what you can't have is you can't have it for just in case. Why have you got this data? Well, these people, they might get back into that just in case. And just in case doesn't come under Article 6. Contract, consent, another legal obligation, vital interest, public interest, legitimate interest. So it's they're difficult until you actually get into the granularity of what the data is and why you've got it, what your reason for keeping it is, the type of organisation you are, and that all comes out on your data map and register, which is why I put so much emphasis on that register.
Great, thanks, Kev. Another for you. How do I know if my organisation is compliant?
That's a good question as well. Firstly, do they have a culture? Is there a culture of data protection? I'm not saying too heavy, you know, but do people, are they aware of risks? Are they aware of potential hotspots? Do they understand clicking on links, opening attachments? So having a culture of information security in some way, shape or form is one way to look at it. The other way is you've got to go back and ask yourself questions on what have we got in place that we can evidence that demonstrates that we're compliant. Do we have policies in place? Do we have the correct privacy statements in place? Do we have a website that complies with consent mechanism? Do we secure people's data? Do you see people's data sitting around on tables or on desktops or in file shares that nobody seems to manage? Now, if I was an auditor, if I was an investigator, I asked a lady this a couple of weeks ago, actually. I might have asked Laura this at one point. Sorry to put Laura on the spot, but I won't tell her what the answer was. If I came into your business, first question I would say to you is, show me your records of processing. If you say, yeah, Kevin, here's our spreadsheet, look at this, and I see the spreadsheet with all your processes on, and it's red, amber, green, and I start to dig into it a little bit, saying, you got a privacy statement here, where is it? It's on the internet. Can I see it? Yep, there it's there. Very good. Use a data processor. You got a contract in place? Yeah, can I have a look at it? Yeah, get out the filing cabinet, there it is. Once I start to look at that register and ask questions on it and then you can evidence what's in there. And I say, why is this red? To be honest, we don't know. We just don't know that at the minute. The ICO will understand that. They're not expecting people to be compliant. They're expecting you to be on the road to compliance, because it's a difficult subject and it needs to mature. But if I come into your organization and say, show me how you maintain records of processing, and you don't put anything in front of me, then I already know that you're in for a tough ride. So get the basics right, build upon it, build upon that compliance, maintain the compliance. You might have a little bit of work to do at the beginning, but then it should just settle down and it should just become business as usual. And you'll probably make an amendment on that spreadsheet, which will be one of your overarching things, as well as your policy framework, once a week, once a fortnight, once a month, and it will just become part of the fabric of what you should be doing in the business. Thanks, Laura.
Thanks, Kevin. So we've got 2 more questions so far. If anyone has any other questions, do pop them down. We've still got a bit of time. Does this apply to me as a sole trader?
That's a good question. It's not a case of whether you're a sole trader or not. It's whether you capture people's data and you process it for a business reason. The GDPR does differentiate between personal use and business use. So everybody that's on the webinar now, I get all of your details. I go home, I put them in the little book next to my telephone. Don't know whether we still have them books next to telephones, but I'm going to. I put your details in, and I'm going to send you all Christmas cards. Well, I'm processing your data. Processing data is everything that you do with somebody's data. It's sending it, it's storing it, it's writing it down on a bit of paper, it's typing it into a document, it's everything that you do with somebody's data. But I'm using it for home use, so GDPR doesn't apply to me. But if I'm at work at the Integrate Agency and I take all of your details down and I put them on a spreadsheet on our corporate system, and I'm still going to send you business cards, I'm processing your data for business use. And because I've captured your data and I determine the manner in which that data is going to be processed, I'm then a data controller. And whether I'm a sole trader and I'm still capturing people's data for business purposes, then it's more than likely that you are going to be a data processor, and then GDPR applies to data processors and controllers, and then you need to comply with the data protection laws. But same again, whoever that person is, I'm happy to have a telephone conversation with you. And I've worked with some really big complex organizations, but I've worked with some people recently that have been quite refreshing. And even though they're quite small, they're actually processing a huge amount of people's data, financial data as well. But their systems were quite refreshing in that it was very simplistic in a way, and it wasn't too onerous a task to actually get them compliant to GDPR. So it's not really to do with a sole trader. It's to do with whether you capture people's data for business purposes and you are classified as a data controller, and the fact that you determine the manner in which that data is being captured and processed.
Great, thank you, Kevin. There's one more so far. So if anyone wants any final questions, then do pop them down. Where are most? I want to know this one. Where are most companies getting it wrong?
Okay, this is a really good point. There's 2 areas where people are getting it wrong. The first area is assumption, and that just leads people down the wrong path. And they then start to work on the assumptions that they believe to be correct, and they're totally off. Their compliance is totally off the mark. And what you actually get from that type of scenario is a duplication of effort and potentially a duplication of cost and time and effort, etc. When I do courses or I go and deliver presentations on GDPR, very engaging with the audience, because I need to hear their thoughts. The amount of people that give me feedback or answer the questions I pose to them, and I say, is that an assumption, is that a guess or a fact? And they'll say, what do you mean? I says, well, you've given me an answer in a really authoritative way, but is it an assumption? Is it a guess, or is it fact? And they'll go, it's actually just an assumption. I says, well, it's actually not correct. But because you've delivered it in such an authoritative way, people would follow that advice and go and act upon what your advice is. I've had people who've done the same, and they've said, Kevin, it's fact. Really? Yeah, definitely. Well, I've got this book in front of me which has all the GDPR articles, and what you're saying isn't written anywhere. So you're working on something that you believe to be factual, and it's not. It's going to take you down the garden path or the wrong path. So I see a lot of organisations that are getting it wrong based on assumption. They're getting it wrong based on being in meetings where people will bang the table, talk with a bit of tone, talk with a bit of authority as if they know what this subject is, and people will follow them, and they're totally wrong, and they've just wasted time and money and effort. So make sure that you understand what needs to be implemented, what you need to be able to do to demonstrate compliance, and follow the correct route of what's written down in black and white of the text. You've also got it's worth mentioning, because it's a good point, you've got Data Protection Act 2018. The Data Protection Act and GDPR are not the same thing. They've got to be read hand in hand with each other. The Data Protection Act 2018 allows us to tailor the data protection laws to meet ourselves, which is slightly outside of what's been standardized across the European Union. That allows us to put exemptions in, non-disclosure exemptions, etc. So yes, it gets a bit difficult, but make sure that you understand what you're dealing with and you put it in the right way. And then secondly, it comes down to the application, and maybe one leads to the other. I see people that don't understand how to correctly secure data. They don't understand terms until it's mentioned to them. Defense in depth, multi-layered approach, lock the cabinet, lock the door, put the alarm on, lock the windows, etc. Breach the security guard up. Layers prevent breach at the end of the day. And then they've not got a start point. And what is the start point in becoming compliant with GDPR? Get your data mapping registers out, start filling them in, and start getting them right. Because once you start to understand that, you'll understand all the areas of GDPR that you need to, and you'll make sense of it. So you've got to have a start point that's going to take you to the next run on the ladder, the next run on the ladder, and the next run on the ladder, in a controlled way that makes sense, and you can see the wood for the trees. So I hope that answers that question as well.
Fantastic, thank you, Kevin. And we're out of questions now. So if there aren't any final questions from attendees, we can draw this webinar to a close. Just to sort of follow up, with Kevin's consent, we will share the slides afterwards, and we will also make this recording available on ERSA's website, on the member-only section of ERSA website. And if you do have any other questions that you think of as you go off, then do send those directly through to Kevin or via us, and we'll pass them on. Okay, thanks for all for attending, and enjoy the rest of your afternoon.
Thank you, everybody.